one, and we are live.
Good morning, my lord. Good morning to one and all. We all joined this webinar on the subject of judicial stress by Dr. Balram K. Gupta, professor and professional lawyer and a judicial educator and national and international level. I wholeheartedly, on behalf of the Karnataka Judicial Academy and on behalf of all the delegates, I wholeheartedly welcome our Honorable President, Srimati Justice B.V. Nagaratna, President of the Karnataka Judicial Academy, and I welcome all the judicial officers of the Karnataka state who joined this webinar, and all the High Court justices on our invitation have also joined this webinar. I wholeheartedly welcome all of them, and I handing over the session to our beloved President, Honorable Srimati Justice B.V. Nagaratna.
Thank you, Madam. A very good morning to everybody, my esteemed brother and sister judges who have joined this webinar, Dr. Balram Gupta, Director of the Chandigarh Judicial Academy, learned judicial officers of the Karnataka District Judiciary, learned resource persons who have joined, Mr. Chetan Singh of SEC Online, the staff of the Academy. Today we have Dr. Professor Balram K. Gupta to address us on judicial stress. And before I hand over the mic to him, a few minutes or a seconds I would take just to introduce the subject. Now we all know about the importance of judiciary under our constitutional democracy. It is essentially to uphold the rule of law. We, the judges, at whatever level we may be, must realize the significance and importance of our contribution to upholding the rule of law. In fact, we, the judges, have a great role to play in that regard in order to make the constitutional democracy work under the framework of a rule of law. In discharging our duties, we, the judges, are bound to be stressed. In fact, it is always said that a judge is always on trial. And if at the end of his career as a judge, if he acquits himself well, then he is said to be a good judge. It all ultimately depends upon our temperament as judges while rendering justice to the litigant public. In my view, if one adheres to the oath of office that we have taken, that is a great mitigating factor in reducing judicial stress. In other words, independence of the judiciary is what is the core of the oath of office that we take. Now, I would not like to expand on this topic today, for we have Professor Dr. Balram K. Gupta to speak to us on judicial stress. Dr. Balram K. Gupta needs no introduction to the Karnataka judiciary. He is a blend of being a professor, a lawyer, a judicial educator at the national and international level. We have heard him speak in the South Zone Regional Conference in the Karnataka Judicial Academy, I think on 2 occasions, if I am not wrong. He has always come to us with open-mindedness when he was at the helm of affairs in the National Judicial Academy as its director. We have had a very good symbiotic relationship when he was there heading the National Judicial Academy. Presently, he is heading the Chandigarh Judicial Academy. He has been conferred the Lifetime Achievement Award by the Rotary International District 3080, and he is a Paul Harris Fellow. I need not say more about Professor Dr. Balram K. Gupta, for his words will be not only motivating to all of us, but ultimately be a source of reducing judicial stress. Over to Professor Dr. Balram K. Gupta.
Thank you so much. I feel privileged this morning to be with the entire Karnataka judiciary. I feel privileged because of the invite and the request from Justice Nagaratna, the President of Karnataka Judicial Academy. You know, this particular aspect of judicial stress is dear to me. I must begin with a confession. I never had the opportunity of judging. And you would question my locus as to how am I competent to speak to you all, the justices of the High Court and the judges of the District Judiciary. My only alibi is that I have grown in that particular environment and have spent more than 5 decades in law and justice. My journey is entirely into that particular domain. And therefore, this particular topic has been a matter of concern to me throughout. Judges do what others normally avoid to do. Harold Lasky, the political thinker, once wrote a letter to Justice Holmes. How much I wish if the people, the judges are human beings. Justice Holmes wrote back to say, how much I wish if judges could realize that they are human beings. And therefore, judges being the human beings, dealing with human disputes is a very challenging task. It's not so easy. That is the real concern. And therefore, what needs to be done is the challenge of discharging this particular responsibility in a responsibility to do justice or to remove injustice is the real challenge. But in the process, it's such a satisfying exercise. The feeling that it gives you, the feeling that you are able to serve the community as such, in fact, the humanity as such, that feeling is a very satisfying feeling. And therefore, in that context, what I have always urged, that the need of the hour is to nurture happy judicial minds. Judiciary or judges or the judicial work or doing justice is not comparable with any other service as such. It's a divine service. I do compare it with the military service which is rendered. These two services, the judicial officers, the soldiers, they make sacrifices and they serve in their own domains as such. With this particular background, the Indian Military Academy produces cadet officers. The judicial academies across the country produce judicial officers. the kind of training which is required to be given to them is something of different kind as such. And to inculcate this at the Chandigarh Judicial Academy, we had a program, month-long program for the JAG officers of the armed services as such. Our young judicial officers under training and the young JAG officers were together at the Chandigarh Judicial Academy for a period of 1 month. They were living together, they were dining together, and they were learning from each other, except that the classrooms were different as such. This kind of blending in judicial education, to my mind, is most important. They learn from each other, and this learning goes a long way in tuning, nurturing their minds. In the army, they face sacrifices as judicial officers also. They face sacrifices. And therefore, in that context, I thought that this particular aspect is very important. Stress, for that matter, in every profession is there. Edmund Burke once said, if you cannot do anything, teach. And yet teaching is not everyone's cup of tea. It's a challenge. It's a challenge which they need to accept in that particular context, for that matter. And therefore, in the entire perspective, take any profession, you need to train yourself. You have to nurture your mind to face the challenges of a particular profession, a particular service that you have picked up. And it is in this context that I wish to take up the issue of judicial stress in particular, for that matter. Let me begin with COVID-19. We have the frontline doctors, frontline paramedical staff, facing the front challenges as such. We know the entire story. Judges are also judicial frontline soldiers. You would ask me, why do I say that, and how do I say that, and what is my justification to say that? Judges, day in and day out, are the observers of the crimes and the criminals, their cases which come before them. Domestic violence cases, child abuse cases, or for that matter, rape, acid throwing, all these kinds of cases. Imagine the kind of impact they have on their minds. The vicarious trauma which the judges encounter in this particular process is just enormous, if I use that particular expression. And therefore, in that background, in that context, the challenges of any particular profession, particularly the judicial profession, needs a particular kind of training of the minds. This is very important. During the journey of a judge, different situations are faced by them. At all levels, made with the district level, made with the high court level, or even the top court level, situations do cause stress in that particular process. And therefore, let me refer to some of the cases, challenging situations handled at the district level. In February 2021 only, Disha Ravi's case, the additional district judge, Dharmendra Rana, has to deal with that particular case. A young lady, 23 years old, and the charge being sedition, a serious charge for that matter. Media publicizing the entire situation in what enormous manner. And handling that particular case was not one of the routine matters for that matter. On the one hand, it's an issue of a young lady. And on the other hand, if it is true that such kind of crime has been indulged into, a serious view needs to be taken of the same. How to balance, how to ensure that you can actually see through the situation, a challenging situation. Yet, Judge Rana took the entire situation in an effective manner, dealt with the manner, came to the conclusion that there is hardly any scanty or sketchy evidence to prove the charge, to establish or even to investigate into the charge of sedition as such. And therefore, if there is a dissent, that doesn't mean that it has to minister to the vanity of the government in that situation. And therefore accepted the challenge and came to the conclusion that there was not enough to really move ahead with such a serious charge of sedition. That was one situation. But it was a situation which needed to be handled effectively with a firm hand and mind for that matter. Or go back to the year 2017, closer to my place in Haryana, Baba Rahim's matter. Sacha Sauda, many of you may have heard and recall that particular case. In the ashram, the charge against the Baba of the ashram of rape of not one, more than that. The CBI judge was the judge who was to try that particular case. Such a situation, volatile in when the judgment was to be pronounced, Lakhs of people gathered. There were threats to the judge, threats to the family of the judge. It was a very difficult situation. One could really come to a situation of this particular kind. I can imagine the kind of stress. The army had to be alerted. The police controlling the situation. And yet, on the day when the judgment was pronounced, such violence, so many people were killed, property of crores worth was destroyed. And yet, the judge, Jagdeep Singh, did not lose his balance, pronounced the judgment. It was such a difficult situation. After a couple of days of that particular case, I rang up the district and session judge and said that I wish to come and meet the entire judiciary, and in particular Jagdeep Singh, who dealt with the matter. I went over, met the entire judiciary, and particularly the judge concerned, Jagdeep Singh. And I asked him, what was going in your mind when you were to pronounce the judgment? And his spontaneous response was, I wanted to pronounce the judgment before anything happens. You know, he was a reflection of the trust and confidence which was built up in the minds of the public, of the people, regarding the district judiciary across the country. That here is a judge, or here are judges who can face any situation. I can imagine, I had even personal talk with him. The kind of threat which was to him and to his family, to his children. Anybody could be a mental wreck. And think of, should I deal with? He stood firm, and he proved that he would not succumb to the stress which he was going through. That was the beauty of how he handled the situation. Let's go a step further in the sense of December 2012. Again, a case which media, a case which had shook the entire nation for that matter. The trial and how it was handled effectively. One can only imagine the stress which could be there as such. And therefore, in the journey of a judge, may it be at the district level, many challenging situations come. And the judges have to conduct themselves to demonstrate the trust and confidence of the public in the judiciary, in the institution as such. That is required only if you are able to ensure that stress will not stress you down in that context. Let's go to the next step, the high courts. many judgments. Now, a particular view is taken by the judge. It may be an erroneous view, but how the public responds to that, how the top court responds to that, causes stress in the minds, even of the High Court judges for that matter. The matter from the Madhya Pradesh High Court, where the judge ordered, Honorable Judge ordered, to go with the wife to tie a rakhi to the lady, and how the public responded, how the top court responded. The stress on the mind of the judge. You know, the question is, a particular view is being taken. And I say, even if it is a wrong view, yet imagine the kind of stress which one undergoes. Or take the case, which again is of recent time, the Bombay High Court. The Honorable Lady Judge, dealing with the matter under the POCSO Act, and laid down the test of skin to skin for that matter. And the response which was there, which could cause stress to anyone as such. And therefore, doing justice is not an easy exercise. It's a difficult exercise at all levels. Let me go still a step higher, the top court. We are passing through the digital times. Justice A.K. Sikri of the Supreme Court dealt with the issue that adjudication during the digital times is the most challenging work or a service that the judges are expected to perform. The media trial, Sushant Rajput's matter, how the electronic media, the print media dealt with that situation. Or take for that matter any other matter, a matter which is in the public domain. So much is written, so much is spoken, so much is debated upon, even before the matter comes before the court. This is what Justice Sikri was focusing in that kind of a situation, in that kind of a background, in that context. And therefore, the stress is understandable. It does cause stress in such times, far more than what it used to be otherwise. Sabarimala Mala case, for that matter, you know, the Constitution bench, 4-1 judgment. And the right to equality, the right of the women to visit the temple, and the limitation which was there, that ladies, females in the age group of 10 to 15 not to visit the temple, was found to be violative of the right to equality under the Indian Constitution. Equality is constitutional morality, and therefore it was read in that particular context. And the view which was taken was in the context that those who wish to visit the Constitution doesn't bar them. But those who believe that they should not be visiting, yes, they have the right of their own faith, belief, freedom for that matter. And therefore the constitutional morality requires and provides that those who wish to visit, open to them. Those who do not wish to visit, obviously, they would not visit. A balanced view was taken. Yes, their opposite view was also there. Yet, Justice Dhananjay Chandrachud received threats in the context of that case. He shared that in one of the public lectures that he delivered. Now imagine, threats, will they not stress a judge, even at that particular level for that matter? You know, this stress was even visible when the Sabrimala matter came in the review process to be referred to a larger bench. Even the reference issue, Justice Dhananjay Chandrachud and Justice Rohindran Nariman had a dissent view. And when the judgment came in that, it was referred to the larger bench, but no stay, and the Solicitor General appearing before the Supreme Court, Justice Nariman specifically said, I don't think the government would honor this judgment as such. This was coming out of a stressed mind that he had at that situation, And then the response of the Solicitor General was, my lord, what makes you feel this? He said, I firmly believe and think that it is not going to be implemented. Now that shows the concern, the stress which even at that level, the Honorable Judge had. Let me refer to another situation. Even at the top level, such stressful situations come. I'm referring to 1960s as such. Chief Justice P.B. Gajendra Gadka, Constitutional Bench, headed by Chief Justice P.B. Gajendra Gadka. K.M. Munshi was the counsel to address the Constitutional Bench. The youngest judge in that matter before the Supreme Court was Justice J.C. Shaw. Each judge in the beginning, including the Chief Justice of India, asked questions to K.M. Munshi, focusing on the constitutional issue involved in that matter. K.M. Munshi started responding first to the question of Justice J.C. Shaw. And immediately, spontaneously, Chief Justice P.V. Gajendra says, Mr. Munshi, I am the Chief Justice of India. Answer my question first. Munshi responded, saying, yes, I would now respond seniority-wise. And he took the questions of each in the seniority order. After having finished his response, Munshi says, my lord, kindly permit me to share with you what prompted me to respond first to the question of Justice J.C. Shaw. And then he shares with them, the Constitution bench, that the question which had been asked by Justice J.C. Shaw was such, if I had responded to that, it would have been a response to all the questions asked by all other judges. Now, normally, we know that Chief Justice P.V. Gajendra, what rich contribution he had made. But such an observation coming from him was a surprise. But that surprise was soaked in the kind of stress that they have to encounter. You know, it is this kind of situation, even at the top level, that we need to train and tune our minds. That's the real challenge as such. You know, let me share with you a lighter moment also. Actual happening in the Calcutta High Court. A barrister was arguing a matter. Serious matter, serious arguments, serious environment in court. The courtroom was adjoining the boundary wall. And outside the boundary wall, an ass started braying. To begin with, the braying was not loud enough. Gradually, it came louder and became louder and louder. The judge, the court was feeling it's being disturbed. So the judge says to the barrister, one at a time, please. Now, when this response came from the judge, the barrister's response was, my lord, I thought it was the echo of the court. Now, see such lighter moments also. And that such lighter moments take off the stress which may be there on the minds, judicial minds. I recall another incident. Let me share that also. That particular incident of the Punjab High Court. The last English judge who became the Chief Justice of the Punjab High Court, Justice Donald Falshaw. A criminal appeal before him. Now, what had happened was the lawyer who was arguing had difficulty in expressing in English before that English judge in particular. As he was trying to make his effort, Justice Falshaw read through the judgment and he observed, why this fatal blow? What is the background? What happened? And the lawyer says, my lord, he stole my she-dog. Justice Falshaw says, what? She-dog? So what? What is she-dog? He says, he dog, she dog. Now, Justice Falshaw was finding it difficult. You mean a bitch? Yes, my lord. Then a fatal blow? You know, he says, my lord, she was not an ordinary bitch. Why? She was from a foreign country, a foreign national. What do you mean? Oh, she was from your nationality. This is how he expressed, and Justice Falshaw took in his stride. Such situations do come up. But, you know, it is the stressed minds and keeping the balance in that situation. In this process, let me also share another particular incident from an English court. An English judge was in the habit of bringing a pet dog to the court. And the dog was so well tamed, will not disturb the proceedings of the court. Proceedings would proceed in the normal situation. Nothing happens as such. One day, matter was being argued, a barrister again, and suddenly the honorable judge started looking at the dog. The lawyer stopped. The barrister stopped. The judge says, Mr. Barrister, why have you stopped? And the barrister says, my lord, I thought my lord is in consultation. And then the judge's response was that, let me assure you, even the dog is not in agreement with you. You know, such light movements also come. And that is actually the recipe to take off the stress which many a time the judges face as such. You know, what I'm wanting to say in this particular context is that in the entire process, challenging situations come, there is no doubt about it. Right from the beginning, what needs to be done is, how do we train the young judicial minds to take the stress, to ensure that stress does not stress them. You know, Chief Justice S. Muralidhar, who is presently the Chief Justice of the Orissa High Court when he was in the Delhi High Court, he said the judges face so many situations and the kind of impact which makes on their physical health, on their mental health, generate different kinds of diseases for that matter. That is really a challenge as such. And that needs to be taken into view in the situation in that context. How to nurture happy minds. That in fact is the challenge of the judicial academies. The very first thing that I always tell the young judicial officers under training, they must cultivate positive minds. Positivity kills negativity. It is only the positive minds who come out to be good judges, who contribute, who are able to do justice in a wholesome manner. Therefore, nurturing positive minds is the basic recipe which right from the beginning we need to inculcate in the young judicial minds. To suspect, the suspicion itself is something which is or which creates negativity in the mind of a judge. Negative minds have never been able to do justice. They may be deciding cases, but if they wish to be free from stress, develop positive minds. You know, I again take an example from the Punjab and Haryana High Court. Our Chief Justice, S.J. Wazifta, what a positive mind he was. Always smiling, never a frown on his face. A case came up before the division bench headed by the Chief Justice. You know, that particular bench was dealing with a particular nature of cases, the roster. And a particular case was not of that particular roster. The bench partner judge suggested to the Chief Justice, let's send this case to the roster judge. Chief Justice Wazifdar said no. You would say, why? He says, before that particular judge, this person will not get the relief. And I feel that he deserves relief in this particular matter. Look at the positivity of his mind. I'm saying all this, that positivity is built up only and only if you have this kind of attitude as such. I share with my young judicial officers the example of Alfred Nobel. You know, Alfred Nobel was one day reading the newspaper in the morning over a cup of tea, 100 years back. And he found his own name in the obituary column. And it was written, King of Dynamite, Merchant of Death. Yes, he was dealing in dynamite. But reading that column, he felt so sad, so depressed that I am being termed as the merchant of death. Immediately, the positivity in his mind, he decided to create a trust to award Nobel Prize every year for the best contributions in different domains: medicine, chemistry, physics, economics, literature, peace. Alfred Nobel is no more. His fragrance of positivity of his mind is nurturing the best of contribution. It is this positivity which kills the stress on your mind as such. It's an antidote to stressed minds in that context. One of the factors which I have always felt the bar and the bench relationship. You know, bar sometimes is aggressive. I belong to that fraternity, and even sometimes on the verge of abusive also. It's a cause of stress, a deep stress on the judicial minds. Then many a time the judges find that the lawyer is not well prepared. You know, the duty of a lawyer is to assess the court. You have lawyers on both sides so that the court is assisted effectively and properly. And when that assistance is not available, the judges do find it difficult to deal with those situations. I recall K.L. Mishra, Kanhaiya Mishra of the Allahabad High Court. He used to go to the Supreme Court of India to argue matters. He argued a matter before the Chief Justice bench, Justice S.R. Das. And at the end of the arguments, Justice S.R. Das said, Mr. Mishra, why don't you come more often to the Supreme Court? Whenever you come and argue a matter, the level of the judgment goes up. Think of it, the Chief Justice of India saying that. Proper assistance from a lawyer. After all, trial judges, trial is a voyage to find the truth. And the lawyers are the instruments to find the truth in that matter. Mishra again, once he was to argue a matter before the Allahabad High Court. A socialist leader had been arrested behind the bars. Now the socialist leader wanted to argue the matter in person. He was not a man of law. Mishra was the Advocate General of the Allahabad High Court. He requested Mr. Mishra that kindly come, assist me, help me with the law and what all I can say on my side as such. Now, Mr. Mishra was to argue on behalf of the state, and the state action of arresting him and behind the bars was in question before the court. Yet Mr. Mishra went to the jail with the law books, the judgments, and briefed him fully as such. His explanation was called as to how could you do this? Is it not against the professional ethics to do that? His response was, what is the duty of a lawyer? To assist the court. Not to keep anything which is against the lawyer from the court as such. I have done my duty. I would do my duty for the state also. And the court would have both the sides, the both pictures before them. That is the kind of mindset of the lawyers. If at all levels we could achieve this, certainly it would reduce the tension on the minds, the stress on the minds of the judges. I feel strongly in that particular context. You know, if judges at all levels get proper assistance from the bar, they are able to write their judgments much better, as even pointed out by Chief Justice S.R. Das. It is in this context that I'm saying another stressful situation is sometimes to keep the judgment pending. And this happens at all levels, in spite of all efforts being put in that particular context. Keeping a judgment pending is again something negative. And not only this, you know, I'm reminded of the Magna Carta of the year 1215, more than 8 centuries back. Justice, not to sell it, not to delay it, and it must be removed at the earliest. It must be done and ensured at the earliest as such. The moment you delay pronouncing the judgment, people start talking. Many things are attributed to the judge. And this is something which is actually stressful. Let me and permit me, in fact, to share a situation at the High Court level. A matter was heard, judgment was reserved. A year passed, 2 years passed, even more. And then a petition, writ petition for writ of mandamus was filed, seeking a mandamus against the judge to pronounce the judgment. When the chief asked him to pronounce the judgment, he sought 3 months' time. The chief did not grant him and said, what I can do is I will not post this particular writ petition tomorrow. You take tomorrow off, write the judgment, and this petition would be before the court in the afternoon day after, and in the morning tomorrow, day after, you pronounce the judgment so that we can render it infructuous. Such embarrassing, stressful situations can happen at any level for that matter. I'm saying this with utmost responsibility, in the sense that we need to follow a discipline which is required. I'm conscious of the workload. I'm conscious of many other difficulties. It's not that I'm not alive to all that. I'm very much alive to those situations for that matter. But then what needs to be done is that you have to discipline yourself. Once you follow that discipline, stress automatically would be out. It's a mindset. Happy minds need to be nurtured in the sense something you must do to break the routine, to break the monotony of the routine. And the first thing which I would say to cultivate, nurture happy minds, enjoy your work. Don't take it as a burden. feel good that you're doing justice. Feel good that you're removing injustice. Feel happy about it. How many get the opportunity to do that? And therefore, you are the fortunate ones that you are able to do justice. This itself is a booster dose to really eliminate stress from your minds and to nurture and culture your happy minds for that matter. You must write something different than what your judicial functions require. Nurture a hobby. Read autobiographies, read biographies, read the life journeys of the best of judicial minds. That is the real reservoir as such, which needs to be cultivated. You know, when you engage yourself, something which you like, even your judicial functioning, and feel good about it, feel satisfied about it, automatically you are nurturing happy minds. For that matter, I know it's a difficult exercise, but it's the way how you view the entire situation. That is why I say the Judicial Academies right from the beginning need to engage young judicial minds into certain other activities also. You know, all this helps in dealing with the situation. I would urge the judicial fraternity that whatever you do in the performance of your judicial functions, feel good about it. You know, the Constitution is your holy book. Do act according to rule of law. Stress would be out automatically. Be in the company of the Constitution. Nurture happy minds, positive minds. I think that is the real antidote for judicial stress. I've heard lectures by psychologists, psychiatrists as such, how to deal with stress. First, we need to know what is judicial stress, what causes judicial stress. The recipe to deal with judicial stress would follow from that. And this, to my mind, is the best recipe. Enjoy your work. Feel good that you are contributing. Feel good that you have taken an oath to uphold the Constitution, to uphold the rule of law. Decide accordingly. Be happy minds. Thank you so much. I look forward to your questions. I have stressed your mind reasonably long, and I'm sure you need to ventilate out of that, for that matter, and come forward. I'll be too happy to answer those questions. I can assure you I am not stressed talking about the judicial stress as such. I've enjoyed it, and I owe my thanks to Justice Naga Ratna for this particular opportunity that has been given to me. Over to you.
Yes. Yes. Thank you, Dr. Balram Gupta, for your lecture, which has really churned our minds and spirits and directed it towards positivity, removed from all negativity with a direction to enjoy our work, be passionate about it, realize our responsibilities, and ultimately to nurture our body and spirits in the sense that a happy mind will ultimately lead to a good body and a good spirit, which I believe is the sum and substance of your lecture today. Thank you once again. Now I request our honorable judges, if they have joined my esteemed colleagues or my brother and sisters in the district judiciary, if they want to interact with Dr. Balram Gupta, say something or ask questions, they are free to do so. Does Mr. Chetan Singh have any questions typed to him?
Ma'am, if I may, I'll just let everyone know. There's a question answer option available in the section which is available in your on your screen,
Yes.
probably on your top right. You can click
Yes.
on that and you can type in your question, and we'll be able to see the question real time. So if you have any questions, please. I think, ma'am, it's more of this session. I was talking to the academy during the session, and I was talking to Gaurav sir as well, and Prashant, and we were thinking that this is more of at the receiving end. This session was more at the receiving end. So having questions would be, I think, I don't know if it will be so many questions or not, and I think that's what it is. I know Balram sir from I think more than 2 years. Balram sir, you're saying something.
Mr. Gill, let me point out one thing.
Sir.
Every judicial officer during his or her journey faces certain challenging situations. I honestly want them to come forward. Feel absolutely confident, feel free to share those situations. This interaction would be meaningful, useful. Saying this, that it is the receiving of it.
Sir.
My idea was not only of giving in that context. My idea is to generate. I've shared those different situations only to kindle the spark in the judicial minds that they also must have faced the situations. Let me share with you another episode. How balanced judicial minds handle the different situations. Chief Justice of India, Justice Hidayatullah, way back in 1969. He was the acting President of India for 35 days. And during those 35 days, President Nixon happened to come on a visit to India.
Yes.
A bulletproof car was brought from US, airlifted, for the purpose of the President of the United States. From the airport, both President Nixon and the acting President, or the Chief Justice of India, Justice Hidayatullah, they were going together. And on the roadsides, on both sides, such large crowds were there. Now we have the television. Most of us watch on the television. But in those days, they used to be out on the roads as such. So Nixon says to the president, acting president, Hidayatullah, Your Excellency, do you ever think that such large crowds would come out to watch the President of India? And his response was, I do not know. Majority of them might have come to see the bulletproof car rather than welcoming the US President as such. Now, imagine how embarrassing it was for the acting President or the Chief Justice. But look at his presence of mind, how well he responded. Judicial minds need to nurture to deal with the situations as such. You know, let me again, and when I'm on Justice Hidayatullah, again, it happened in 1969. He was presiding a 3-judge bench in the Supreme Court. Our appeal was heard and the judgment was being dictated in the open court. And suddenly one particular person jumped across with a knife in his hand. Justice Ian Grover, some of us would recall, had 2 stab wounds in that particular process. Justice Hidayatullah held the hand of that particular person and saved further ugly situation. He was profusely bleeding. What I'm coming to next is the most important aspect of it. In some situation, Justice Grover was put in the car of the Chief Justice. And would you believe Chief Justice Hidayatullah himself drove the car and within minutes was in the hospital? Saved Justice Grover. Look at this situation. He himself was under a shock, yet he drove. See, that's the beauty of judicial minds, the balance of judicial minds. I'm very fond of sharing Lord Danning's quote happening. Since maybe that some of your questions could be answered during this particular kind of supplement that I am adding to this situation. On Mondays, Lord Danning used to hear the petitions of those persons who would appear in person and argue. And Lord Danning in his life story says, the most difficult cases are those which are argued by the person in person. So on a particular Monday, a lady appeared, argued the case. She was given, and the petition happened to be dismissed. The moment the petition was dismissed, the lady got furious. Pardon my saying, the fury of a lady can be a real challenging situation. You know, there were 3 books lying in front. She picked up a book, threw at Lord Danning. Before he could realize what happened, the second book came flying across to him and the third one. No more books. Danning didn't say a word to her. Didn't ask the orderly to stop her and issue a contempt notice. Nothing of the kind. Didn't utter a word. She walks up to the exit door, stands there and says, how cool, even in a war situation, and she walks out. When she goes out, then Denning says, I dismiss the petition, sudden provocation. This is the consequence of that. And that was the end of it. You know, this shows no stress. This shows how you have to take difficult situations. Many ask me that does it not mean, in spite of the contempt having been committed, yet no contempt notice? The answer is no. In such situations, how you handle the situation, with what equilibrium of your mind, how one thing which I want, a judge should never lose his or her temper. And that is the recipe again of not being stressed as judges. I can really go on with stories.
There are two questions, Dr. Balram. May I intervene?
Yes.
There are two
Yes.
questions. May I?
Can I know the question? I mean,
I'll just read it. One is, sir, it becomes very stressful for a young officer when two opposite counsel fight in the court hall over a point. How do you think such a situation can be handled by the officer?
yes.
And
Now,
the second,
let's
yes.
answer to this. This situation often happens, particularly difficult for the young judicial officers. You know, when such a situation comes, my response is just adjourn the matter. In the sense, when the tempers are high, matter can't be adjudicated properly. And therefore, adjourn the matter and take it on some other day. Hear the parties, decide the matter. This is the best way to deal with a situation rather than saying anything to a lawyer on one side, to a lawyer on the other side. Tell them that you seem to be generating more heat than light. And therefore, we look forward to a day when you would be able to give us more light than heat as such. Adjourn the matter.
Yes.
What is the second one?
Second one is, it says staying positive requires responding, then reacting to a situation. Evaluate the situation and then respond to it. How can we put ourselves in that zone every time we receive a stressful situation, considering our courtrooms are filled with people with conflicting situations?
See, that my answer to this is your mind need to be absolutely cool. You, as the situation is happening, you are viewing the situation and respond with effective coolness. Take, for instance, Lord Denning's situation. It could shake many in that situation when the books are being thrown across to him. Best way is keep your cool. Don't lose your cool and respond. I'm sure you would be able to respond constructively to deal with the situation. And the recipe of adjourning a matter is always good as such. If you find the situation is not congenial enough to deal with the matter, even say we'll take it up after lunch.
Yes.
That itself will give you time to think it over.
Yes.
And deal with it.
Third one is how to promote positive workplace environment, as some judges have administrative work.
Could you repeat the question, please? Sorry.
How to promote positive workplace environment as some judges have administrative work. What
Yes.
measures do you suggest to promote positive workplace environment for judiciary?
Please. You know, this is a very healthy question and needs a serious consideration. Positive environment to work is something which is very important. In fact, judges themselves need to contribute to that. And judges need to be dealt with in a particular manner so that positive environment emerges. First, let me share with you how a judge creates a positive environment in court. Certain judges are also aggressive. And the environment in court is a fear psychosis that a lawyer is not able to give his or her best in such situation. I have faced myself as a lawyer. You know, what happens is, if a healthy environment is there, tense court atmosphere is not there, surely the lawyer would be able to assist the court much better than otherwise as such. I remember we had Justice Pramod Kohli. One day I shared with him at a social gathering. I said, the bar is very happy with my lot. He smiled and he says, Balram, do you know what I follow? As a lawyer, what I faced the difficult things, I make it sure as a judge, I should keep in mind that the lawyer doesn't suffer from those difficult situations. That's the mindset of a judge. And that helps the entire judicial system for that matter. That's one side of the story. The other side of the story is the workload, the management of the bar as such. If we are able to do that, what happens sometimes in creating an environment which is positive, where it will be more effective. What happens is certain judges patronize certain lawyers. And it goes around in the bar that in this court, only such and such lawyer or these lawyers get the relief. Kindly make sure the judges are urging them that not patronizing any lawyer. That creates difficult situations. And therefore, you treat everyone equally and follow a certain discipline. Yes, if you find that there is a sufficient reasonable cause to give an adjournment, do it. But let the message go around on the asking alone that you will get an adjournment will not be a healthy situation. And therefore, create an environment yourself where you will be able to contribute more effectively than otherwise in that context. There are many other situations. It depends upon a situation, how you deal with it, how you handle it. But I'm sure positive environment is in the hands of a judge to a large extent.
Next question is, how can the judge pass on the positivity to the counsel and more importantly to the parties, particularly when the cases are running for so many years and people are stressed on account of the long pendency of cases?
Please. You know, a judge can contribute in contributing positivity to the lawyers, to the parties as such. If the lawyers know that even a case which was pending for 10 years for matter, or 6 years or 7 years, if it is heard in this court, it would be given top priority. And how that judge deals with that case itself would convey the positivity to the lawyer, to the parties also. It is something which flows from your conduct, from the manner in which you hold the court, conduct the court, and deal with judicial matters as such of adjudication. I gave the example of our Chief Justice Wazir Dar, that he kept a matter which was not of his roster. Why? He knew that he would not get the relief in the other court as such. That demonstrates the positivity of the bench. And therefore, so many ways when you deal with a matter, you can percolate positivity, different stakeholders, lawyers, parties as such. And that would even create an image of the judge.
The next question is about So the next question is about media trial and the stress it causes on the judges, whether the judge should isolate himself from what is being written or stop watching television or continue to read newspapers and watch television even while he's hearing the matter, which is broadcast or written about.
It's a real challenge. It's a real question. And in fact, Justice Sikri, just after his retirement, dealt with this particular issue as such. And therefore, he came to the conclusion by saying that in the digital times, particularly the media trial, the print media, the electronic media, so much appears as such. And therefore, for a judge to isolate completely is a complete impossibility. You can't just close your mind, your eyes, not to read anything, not to hear anything as such. But in that particular process, even in court, when both sides argue, many a time a counsel arguing on one side, we feel that this is the only view which is possible in this situation. And when the counsel on the other side argues, then you realize that yes, equally balancing view on the other side also is there. Therefore, the judges in court need to keep in mind that you are going to give a fair opportunity to the parties and let the parties come forward. Consider those aspects as such. Even if you have been hearing or reading something, that itself would not be carried in your mind that when you hear the arguments in the court. We know about Sushant Rajput's matter. So much on the electronic media. Every day the debate going on. And now the investigation. And therefore, ultimately, see, a trial judge is on trial throughout. And yet the trial judge has to maintain the neutrality throughout for that matter. Therefore, my caution is, even if you read or hear, yet we have to cultivate open minds, open to conviction. We often hear that. That is what a judicial mind. This is the beauty of a judicial mind. And therefore, let no other consideration be predominant. Hear the parties and decide according to rule of law. That is what is the end recipe. Please.
So recently, there's been a new trend of parties appearing in person in courts. They lack legal knowledge. They misinterpret what they have read. They try to bring irrelevant matter into the case and try to expand the scope of their petition. Dealing with party in person who appear in person has become a big challenge for judges. And secondly, another trend is where the advocates appear as parties. That is another challenge to the judges now. So how to go about it when these parties in person appear in courts?
See, you are absolutely right, my lord. In the sense, cases to be dealt with when the parties insist or wish to argue in person. Certainly, those are difficult, challenging situations. Denning has accepted this. And in times when he was there, not in the present situation, the kind of situations we face. And therefore, a judge has to convert himself or herself to a given situation. One of the ways to deal with a situation is you hear him. If he continues to insist that I must be heard more on this, tell the party to give written submissions and they would be considered as such. You need to put an end to something. When a person appears in person, emotions prevail. As you said rightly, that little knowledge of law for that matter. And in the process as such, emotions prevail, logic suffers. This is the only way, yes, uninterruptedly give a hearing to that particular party. And if the party still continues to insist, I would suggest ask the party to give the written submissions. Consider those and decide the matter as such.
The other
I'm
aspect
sure my lord's experience would be still more to share with us in this particular context.
Yes, I feel that with my experience, what they want is ultimately to ventilate their grievances. So some time has to be given for them to ventilate. And once they exhaust themselves, they become more normal.
Absolutely.
It's just a matter of 5 or 10 minutes.
Hear them. That is what I was saying, and that's exactly what you are.
Yes. Now, what the other problem is when the advocates become parties and they start arguing as party in person. They become, they have a dual role. They have complete knowledge of law, so to say, and they also want to argue as parties. And in another case, they may be arguing as an advocate. But in this particular case, they are a party having, having legal training, etc. So then they try to become very aggressive, doubly aggressive.
See, again, as you are saying, don't counter them. Even they are saying the situation is to be dealt with ultimately by telling them, give your written arguments, written summations as such. Because, see, to that, they can't say no. You have heard him or her, and thereafter, written submissions. That is probably, to my mind, is the best way to deal with a situation, rather than aggression in court on that side, and losing your cool yourself as such would not be a happy situation.
The other question is, the judge is not always stressed, but he appears to be stressed. Then how should that conduct be expressed to a lawyer?
Please, let me put it, this situation more with the young judges as such. You know, I always tell a young judge must know the file, must know the procedure, and must know the basic law to deal with the lawyers in court. And this kind of little homework would go a long way to deal with situations in court. In that context, there would be no stress. I understand, and that is why I have been urging the judicial fraternity, we need to introduce for the young judicial officers mentoring scheme as such. Initially, even when they are under training, in the academy, attachment with the courts, you need mentors to monitor them, to guide them, to counsel them. And after they start performing judicial functions, at least for 2 to 3 years, you need mentoring to be done. Otherwise, they will not gain confidence. They must have somebody when they are in doubt. They must have somebody if you are in difficulty of any kind. Surely, senior judges acting as mentors. After all, judicial education is ultimately senior judges sharing their experiences with the younger judges. And this mentoring recipe also is important to build up the confidence of the young judicial officers in the initial stages as such. Once that confidence is there and they are into the system for that matter, I'm sure they would not have any difficulty in that context.
So how to ensure that judicial stress does not have an impact on the family of the judge? In other words, the family of the judge should not be at the receiving end of the stress that is passing in the mind of the judge.
Very good question. You know, when we talk about the family, it's traffic. Peace at home, peace with the family is something which is important for a judge. That takes care of the stress to a large extent. If a judge is stressed at home for that matter, he or she will not be able to contribute and would be stressed in court also. On the other hand, a judge, we are trying to build up a situation, an environment where judges should not be under stress for that matter. But many a time, happenings do take place. And if the judge shares with his wife a particular situation, that in itself should be a ventilation for the stress part as such. After all, judges can't go and share with any and everyone. With the family members and with the close ones, surely they can share that. And sharing takes care to a good extent the stress which is on the mind of a judge. And gradually the judge needs to learn how to take the stress and be free from it as such. That's how I would look at it.
Can you suggest a simple exercise in that regard to have a positive mind or a balanced mind, a simple exercise?
See, physical exercises, I'm sure, for instance, meditation for that matter, is said to be a very good way out to create positivity of mind, to deal with stressed situations, to have your mind at peace as such. Meditation makes to a large extent. In fact, mental health, physical health, the yoga, the meditation, all these would go a long way to deal with such situations as such. This is how I would look at it. But a person who is a yoga coach or who deals with such physical exercises, meditation for that matter, would be a much better person. But my recipe is enjoy your work. Once you enjoy your work and don't take it as a burden, believe me, you would not be stressed. I take my own example many a time. I still continue to work only because I enjoy my work. And that is my sustenance. And therefore, I would urge the young judicial officers also. See, be confident about the work that you are doing. Don't take it as a burden. Enjoy your work. Feel good about the contribution that you're making. Be happy minds, be satisfied minds. I'm sure that itself is an exercise. I'm sure you would agree with me on that too.
So, judges who are in the family courts, who are dealing with matrimonial cases, are particularly stressed, since many a time the children are at the receiving end, custody case maintenance, bigamy. These cases cause deep stress on our family court judges. How should they handle it?
See, yes, family courts need to be handled differently, skillfully. They are to be managed as such. A family court is a different game ball. And I think some kind of workshops need to be conducted to deal with the family court matters as such. That is one aspect. Then judges need to be sensitized on gender issues, on issues which concern the family courts. It's very important for that matter. Recently, the Supreme Court has come forward and in fact has desired the National Judicial Academy to work out a program, a workshop for gender sensitization to deal with the family court matters, to deal with the POXO matters, and to deal with certain other similar nature as such. See, these are specialized areas. And therefore judges need to be trained in that. But besides this, what I would say, a judge should not carry back home to the family the problems that are faced or they are dealing with in the family courts as such. They are finding solutions to them. They are adjudicating those disputes. They are solving those disputes. And therefore, they don't need to take them back home. Feel good that you have been able to handle the situation in this particular manner, positive manner as such. You have been able to resolve that particular family dispute effectively. Take pride in the fact that you have been able to join the parties together. And therefore, a specific mindset is needed to be trained into that particular domain. I'm sure this exercise can go a long way.
So recently, there's one new trend where a lot of anonymous petitions or even petitions from the bar, etc., are written to the High Court against our district court judges, district judiciary judges, many of which is not true. They are just as a result of losing the case. So a lot of vigilance issues arises in the sense that these anonymous complaints, etc., that gives a lot of stress to our officers.
I totally agree with you. And whosoever has asked this question is absolutely
I'm Nagratna speaking for our district judiciaries. Nagratna.
See, this is not a recent problem.
Yes.
This problem has been manifesting from good olden times also. Complaints the judge, petitions against vigilance issues involved as such. This is something which is in a way inherent with the system. Two parties, one losing, one winning, and therefore it generates that kind of a situation which causes stress undoubtedly. I'm sure the high courts need to have a very positive attitude as protectors of the district judiciary. They need to play that role. Erroneous decisions, but as long as no motive is attributable, that no motivation is attributable, the entire judicial system, a trial court decides, it goes on appeal. If wrongly it has been decided, it would be rectified at that level. Still the second appeal, we have that system for that matter. And therefore, the High Court needs to generate the confidence in the district judiciary. That role is very important. If our district judiciary would be stressed, trust me, they will not be able to do justice. And I'm not saying that even where actually a wrong needs to be punished, don't punish. I'm not saying that. I'm not saying don't punish the wrongdoer. But we know in majority of the cases, the district judiciary is not at fault. And therefore, a protective role is important to generate confidence in the district judiciary. They need to be protected. Otherwise, it can lead to a difficult situation. And the system would collapse in that context. A very basic, balanced approach is required in this context. Please.
Yes. Are there any more questions?
I I think no more questions, my lord. May I propose, Ravi Kumar, my lord, may I propose vote of thanks, my lord?
1 second. Before the vote of thanks, our director, Madam Hiremat, would like to say anything? No. All right. Madam Director Hiremat will give the vote of thanks.
Good afternoon, my lord. Good afternoon, one and all. This webinar is being arranged because of the initiation taken by Her Ladyship, Srimati Justice B.V. Nagaratna, Judge High Court of Karnataka and President of the Karnataka Judicial Academy. I wholeheartedly thank Her Ladyship, Honorable Srimati Justice B.V. Nagaratna, Judge High Court of Karnataka and President of the Karnataka Judicial Academy for providing this opportunity to all the Karnataka judicial officers. Thank you. By accepting our invitation, the today's speaker, Dr. Balram K. Gupta, former Director of the NJA, Director Academicians, Chandigarh Judicial Academy, Professor and Professional Lawyer and Judicial Educator at national and international levels, has agreed to deliver lecture on today's topic, judicial stress. Dr. Balram Gupta has addressed the issues. Normally, how the judges will suffer from judicial stress in dealing with the sensitive matters with reference to the cases. How to press down the same, it is necessary to press down such stresses. He gives few examples how the stress can be encountered in the open court. The speaker has emphasized that it is the responsibility of the judicial academies to cultivate the young minds, to cultivate the positivity, and he has given several tips like how to mentoring the same and breaking the monotony, enjoy the work, feel cool, feel happy, and read autobiographies, especially judicial mind autobiographies, and we feel that we are fortunate to deliver the justice. Therefore, it is a very useful to our Karnataka State Judicial Officers, and I thank on behalf of the Karnataka Judicial Academy and on behalf of all the participants to Dr. Balram Gupta. Thank you, sir. By accepting our invitation, Honorable Judges of the High Court of Karnataka have joined this webinar. I thank Honorable Justices of the High Court of Karnataka for gracious presence. Upon our request, SEC Online team is in coordinating in conducting this webinar. I thank Sri Chetan Singh Gill, Manager Training SEC Online, who is coordinating this webinar. Thank you, sir. I thank all the participating judicial officers working in the state for being part of this webinar and putting a very beautiful questions and actually participating in the webinar. Once again, thank you, one and all. Thank you.
I need a word. I need a word to respond, please.
Yes, surely.
You know, I feel so honored that the honorable judges of the Karnataka High Court and the District Judiciary associated with this particular webinar. It's a privilege for me. It's a joy for me. I've enjoyed this morning and the afternoon of it as such. Thank you so much, particularly Justice Nagaratna, for giving me this opportunity. And I look forward to more opportunities to be with the Karnataka Judiciary. It is such a pleasure. Let me also thank the Director and Mr. Chetan Gill for providing this particular platform so that I could, whatever little I could contribute in the whole process as such. I am indeed indebted to the Honorable Justices of the Karnataka High Court. I feel deeply honored for that matter. Thank you so much.
Thank you, sir, and we welcome you again to the Academy for your more insightful advices in future. Thank you very much.
Thank you. Thank you so much.
Namaste.
Namaste. Grateful.
I'll end this meeting now, and the recording would be available to the Judicial Academy, and all the members can seek the copy of the same from the Judicial Academy. And with everyone's approval, I will end this meeting and end this webinar now.
Thank you, Mr. Gill. Yes,
Thank you, yes, ma'am. Thank you, ma'am. We'll end this meeting now.
Yes.